Okay, my name is Ronald Spirn. Good evening, everybody. I imagine that Mr. Heller is just being detained momentarily, but Pinny will be here shortly. This is the asset protection planning session, and asset protection planning is really another way of saying Medicaid planning, because you can't have assets in your name above certain limits. That's Pinny Heller.
Sorry, everybody.
8 seconds. Sorry. Ray Mockman here.
Okay.
The whole instructions, so good. No problem. Right, you have to shut your phones off, please, because they're recording it, so they don't want it to interfere. All right. So this is the asset protection planning session. I have been asked to do a proper introduction of my other panel member this evening. Unfortunately, our third panel member was unable to make it at the last moment. That was Mr. Eli Happ. And it's a good thing because they gave us a small table. But we'll be sure to cover that information as well, so you'll get the full array. So, Pinny Heller, the gentleman to my left, joined Senior Care as its director in September 2004. He's a graduate of NYU. Pinny spent 16 years at Prudential Securities, first as an analyst in the new accounts department, and later as a first vice president. Since joining Senior Care, Pinny has been able to utilize his knowledge of all types of financial accounts, IRAs, annuities, stocks, mutual funds, and CDs in assisting families with their financial planning, specifically in the area of preservation of assets in preparation for the Medicaid application process. So, although Pinny and I are completely separate and have totally separate roles and functions, we oftentimes get to work together when assisting families, individuals and their families, to protect assets. So what I'm going to be speaking about for the first part, which is going to truly be about 20 minutes, is the interplay between elder law. I'm an Eldercare attorney. I've been doing it for 21 years. I'm a certified elder law attorney. I've helped thousands of families get through this process, but ultimately, after they get the legal clearance, they get handed to Pinny's office, or vice versa. So that is what I will be talking about as well. I want to also differentiate between advanced planning and crisis planning. Unfortunately, I would say anecdotally, about 50% of the cases of the families that come into my law firm are in a crisis. Dad had a heart attack, mom had a stroke, somebody's 92 years old and is just finally lost it completely. They own a house, they have money in their name, and they are concerned about that being consumed and being wiped out. So I'll be touching upon the differences between advanced planning and a crisis Medicaid planning. I just wanted to let you know also that if anybody has any questions, what you can do is, I'm going to ask Esty Levinson, one of the attorneys from my office, just raise your hand, she'll give you a card, and if you could just write it out on the card, then she'll collect it, and then at the end, we will, Penny and I will be happy to answer any of the questions, time permitting, and if not, then we are, of course, will be here after the session, and we could get to your specific questions. So, elder law. The foundation of any elder law plan, of any Medicaid or asset protection plan, is that the person who needs those benefits, the person who is interested in having their home or their assets, their money sheltered, is that they have a power of attorney. A power of attorney is a very broad and vague term. Yes, it means a document that you give another person authority to act on your behalf, However, there are numerous different types of powers of attorney forms. So you are urged to do such a form, which is available on the internet. It's available in legal stationery stores. However, almost every time that somebody comes in with one of those cookie cutter forms or off of the internet, or their nephew who's a real estate attorney prepared, it is insufficient to get everything done in terms of the entire process of sheltering assets to the point of getting approved for Medicaid and being approved for home care services or nursing home services, which what Pinny will talk about shortly. So we're talking about a general, durable power of attorney. And not only should that general, durable power of attorney form be completed, but there is another attachment. It's called a statutory gifting rider, an SGR. Now, gifting is a legal term of art that crops up often in the realm of asset protection. It doesn't mean a wedding gift or a Hanukkah gift. It means a transfer of assets for no consideration. So if a parent has $100,000 and the parent is not doing well, they want to shelter those assets. And in order to be able to do it, if that parent does not have the requisite mental capacity to do so, it better be in writing and it better be crystal clear. Otherwise, there's going to be an immediate impediment to being able to implement such an asset protection plan. So from the beginning, from the get-go, we're not talking about money, we're not talking about bills, and we're talking about who has the legal authority to act on behalf of, let's say we'll just call it the example of the parent, the loved one. The same way that there is a document that gives you the authority to make financial or legal decisions on behalf of another person, there is a document that is also absolutely advisable that everybody have in terms of making medical or health-related decisions. And that document is either a healthcare proxy, and we're going to get a little bit now into the differences between a standard healthcare proxy and living will, and I'll touch upon the halachic living will. So a healthcare proxy is an individual who can make medical decisions on behalf of a loved one or anyone that it is put down in writing. You can't name more than one medical proxy agent at a time, which is to be distinguished from a power of attorney. If the parent wants to name more than one, let's say, child as an agent under a power of attorney, the parent can. They could name 2, they could name 3. We really try not to let it get too out of hand because then it's a lot of chefs and it's a big pot of broth. So we say 2, 3 is the maximum. So on a healthcare proxy, because the government doesn't want people to run into a situation where there could be disagreement about medical decision making. Should we do an operation? Should we insert? I mean, these are literally life and death, health-related questions that arise. If 2 kids are going to disagree, should we close out mommy CD or to get a better rate of interest or not? All right, so what? Nobody's going to get hurt if they disagree about opening or closing a CD. But for medical purposes, you could only name one individual at a time with successors. So you could have 3 or 4 names, but number 2 does not act unless number 1 is unavailable. Okay, that's a healthcare proxy. A living will is a legal document that a person sets forth their end-of-life decision-making wishes. This is very, very powerful stuff, and in a moment we're going to drift into the halachic realm. Now, I'm not a Rav, I'm not a posek, so you have to go to one of those individuals if you have this question. But I've seen as many people going one way as the other way, from Erlich, nothing. It doesn't matter. Everybody has their own matzav. But a living will says, generally speaking, if I become incapacitated, comatose, in a persistent vegetative state, I'm speaking generally, folks, I'm not a doctor either, then I don't want to be left alive, or kept alive through artificial means, such as respiration, or nutrition, hydration, an NG tube, or a PEG. A person says, if I'm not going to make it, let me go. All right. That's what a living will addresses. It's an end-of-life decision-making document. Halachically, they combine the healthcare proxy and living will component into one form. I think the most well-known form is the Agudas Yisrael of America. They put one out a number of years ago, and those clients of mine who wish to have such a halachic document, the halachic living will, of course we accommodate them, and they have to supply the name of a Rav, or the name of a I don't know if it's a yeshiva or an institution of higher Jewish learning, in order to make sure that their wishes are put into effect. Those three documents, the power of attorney, the healthcare proxy and living will, or the halachic living will, must necessarily be the foundation of any elder law or any asset protection plan. Why? Because if a person comes into the lawyer's office and says, my dad had a stroke and he owns a house in Brooklyn and it's worth $650,000, and we want to get Medicaid, what do we do? Well, they can get the Medicaid, right? And Pinny will talk about that, but the house is going to be an issue. So that if the person does get the benefits, it could be that at the end of that person's life, the government is going to say, payback. You sell the house from the estate, and there's a payback. In order to avoid that, and to try to do advanced planning, we encourage folks to shelter their assets, whether it be the home, whether it be the liquid assets that they have. And we'll just keep it general this evening. Yes, there are all sorts of different types of hybrids, and there are IRAs and Keogh plans, and people have property in Switzerland, and people are receiving Holocaust reparations monies. So all of these issues, everyone, because Medicaid cares about every dollar. Would you agree with that, Penny? Every dollar.
Every penny.
Every penny. Thank you. So nothing goes not unreviewed. Okay. So if a person comes in and says, Dad has the house, now he needs a nursing home, we don't want the nursing home, let's say, to, even though a nursing home would never take a home, that's a little bit of a misnomer. It doesn't work like that. You just have to deal with the eligibility component or the payback component. If they're in a crisis and they don't have a power of attorney form, and they don't have legal authority to act on behalf of their parent, they're stuck. Or they would have to go to court and commence a guardianship proceeding. You would have to go and you would have to appear before a judge, and you would have to petition the court that you be appointed guardian. In the meantime, you have to give notice to plenty of people about your desire to pursue guardianship. And all of those other people that get noticed have the opportunity to come to court and to dispute it. Why should you be Daddy's guardian? I'm the one who took care of everything all the years. Just because I live in Jersey and you live here. So the best way to avoid that type of a tragic situation, a potential fight in court and a guardianship proceeding, is to put it in writing. So it's always better to do advanced planning, and that's why the powers of attorney and the medical proxies are the foundation of any elder care and any asset protection plan. Okay, so we have the documents in place, there's a good power of attorney, and the family comes in and they want to protect the house. What should they do with the house? So 20 years ago, a little after I started practicing in the elder law field, it was still kind of common that parents would put their residence into the children's name. Okay, I trust my kids. Why not? Well, we found out that years after, a lot of problems arose. Because when you put your house, or a parent puts their house or money into a child's name, you know who now owns that house and that money? The child. So, yes, there are some clever ways of doing it. There are some life estates, and the parent can retain control. But then we saw cases where, unfortunately, a child that had the house transferred into the child's name by the parent passed away before the parent. Now the parent's house got schlepped into an estate proceeding that they never intended. Or a child can be sued, or go bankrupt, or get divorced, or get sick themselves. So I would say 10 years ago, 12 years ago, the tide really changed in a monumental fashion so that they weren't doing transfers of assets to children, but instead we were creating and establishing for the parent an asset protection trust. An asset protection trust is a means of a person putting their assets into that trust. And if they put the assets into the trust at least 30 days in advance, or in some places 90 days in advance, then they can go to Pinny, and Pinny can get them home care Medicaid. If they put it into a trust at least 5 years in advance, then you can get the nursing home Medicaid. So advanced planning is key and critical for the nursing home, because there's a 5-year look back and penalty phase, but also to get that clock ticking, even if somebody says, oh, I just want home care. Halavai, everybody's wishes should be fulfilled, and nobody should be sick, and nobody should need home care or anything like that, but the way the world is, that's how it goes. So the trust is definitely an excellent method of having a person's assets sheltered. They can qualify for Medicaid. They are able to retain control of the assets. The taxes stay the same. When that person passes on, those assets will avoid probate because they're in a trust, and assets held in the name of a trust instrument will avoid probate. Probate is that procedure when a person passes away and they have assets in their name, and then the will, if they have a will, if they don't have a will, it's called an estate administration, but if they have a last will and testament, then that will is offered for probate, and you have to pay a lawyer, you have to pay the court, there are court costs and filing fees. So assets that are put into a trust avoid that rigmarole as well. So anybody has a question, just write it down and she'll give you a card. Thank you. So anyone that puts assets into the trust will get those benefits from the trust. I'm going to wrap up just this portion quickly by talking about last wills and testament, which I just touched upon briefly, in the context of doing asset protection, and you'll see from the handout that was on your chairs, that there are two kinds of trusts, revocable and irrevocable. For the purposes of this session and this discussion of asset protection planning, it must be irrevocable, that it can't be changed. Last wills and testament, everybody should have one. Thank you. Even if they have the trust, just in case, one never knows. Thank you. When an asset may be acquired after a trust is established, it happens all the time. People get refunds from their income taxes, or people get an inheritance from somebody else, you never know, or something is sold. So a person, even if they have a trust, should also have a will, and there are different types of wills, and when you sit down with an attorney, the attorney will definitely be able to guide you through that process. So at this point, I'm going to turn, thank you, the table over to Pinny Heller, and Pinny, go for it.
I hope you don't mind if I stand. I was meeting with a family on Thursday. It was interesting. The whole family came in. We were talking. And at the end of the session, I guess I did okay, and the son says to me, you're very good. There's a big seminar going on Sunday. They should get you to talk. So I told him, all right, look at the ad. Anyway, I just wanted to say, I'm a little bit different than Ron, a little bit. Ron, I think, does a lot of planning. I know at least I send him quite an amount of business, and for the most part, they're planning sessions. I'm sure he deals with emergencies too, but mostly planning. I'm the other way around. I deal mostly with people that come in tremendous tsar, so I see the tsar. So I want to say some things a little bit stronger maybe than Ron did. I see the pain of people whose mother or father or loved one is in the hospital about to be transferred to a nursing home, maybe permanently. And they never did planning. And the pain on their face, besides the medical issues they're dealing with a parent, they're dealing with these enormous financial issues that are just hitting them now. No one's ever talked about this. They never knew this. As many of these seminars that go on, it's like a minute amount of people that come to these things, and you should all, a big shikayach to all you people, because it's a tremendous kibbut av aim that you're all doing here for your parents or for other loved ones, or maybe even for yourselves. It's a tremendous thing that you did to take out your time to come here to hear us. But that's what I deal with a lot in my office, and it bothers me so much. And so many people come to my office and they say, "I wish we had met you 5 years ago, 6 years ago. We couldn't get my parents here, or me and our brothers and sisters, we were fighting about this. It was so difficult. This is such a difficult concept to explain. I kind of always make it the analogy to Hilchos Avelos. Nobody knows Hilchos Avelos because no one ever wants to learn it. You only learn it, unfortunately, when you're sitting shiva. It's such a terrible thing." And this is something that it's understandable that people don't talk about. So like I said, I see the pain, and I want to say a couple things. Ron mentioned, he spoke a lot about powers of attorney. Please go get a power of attorney. It is so important. It seems like so trivial, but I deal with the tsar when someone said, my father just fell into a coma. They won't let us do anything. And the investment broker that you thought you had such a good relationship with, if your name is not on that account, they will freeze the money. You can't do a thing with it. You can't save it. You can't apply for Medicaid. You're stuck. The house, forget about. I see this. Guardianships are extremely expensive and extremely difficult. And people just want to avoid them like anything. The most important thing you can do, and it's such a small matter, your mother or father is healthy, get the power of attorney. Ron mentioned it. People say, oh, I'll go to Staples. Oh, I'll go online. I'll download the form. Spend the $500 on an attorney. They are so important. They'll get you the right forms. They'll make sure it's valid. They'll make sure that it's covered in all areas. I deal with people who come into my office and they show me the power of attorney. And I show them about what box wasn't checked off. It's meaningless, the power of attorney. I can't believe it. My mother signed it when we got the early signs of dementia. Now it's 2 years later. She can't sign anymore. These are tremendously important things. My time is limited, so I'm going to go very fast. If I need to, just please tell me to slow down, but I'm going to try to get a lot in. If you mind, by show of hands, how many people are here because a parent is already on Medicaid? Okay, not too many. So I won't spend too much time on this. I gave out these handouts on the chair. They only really apply to people who are already on Medicaid. There's something new. You'll see signs about it all over the place. Buses, street signs, they're all over. It's something brand new. It's called FIDA, F-I-D-A. It really only applies to people already on Medicaid, so I won't spend too much time on it. If you have any specific question, you can always, I gave out excellent handouts. They came from a law office, and I whited out it because I didn't get reshus, but the information is out there on the internet, and I didn't get a chance to call the person first, so I didn't want him to be bombarded with calls. You can call me if you feel like it to ask me any specific questions. I'm also going to cover just general topics. You know, I met a lady downstairs who's asking me about her personal situation, and she said she wanted to come. I said, if it's personal, don't waste your time, because I'm going to talk very general topics. I want to try to hit as many topics that can affect everyone in this room. So I'm not going to concentrate on anything personally, but I'm going to go over some major general ideas that you need to know. Okay, very, very quickly. There's so much misinformation out there. Way more than the information. Way more. I want to go over some important pieces of misinformation. Number one, so many people say, can't get Medicaid, my parents have a house. That's the biggest. Okay, that's absolutely a piece of misinformation. There's so many things, as Ron was mentioning, that you can do with a house. So many things that you can do to protect the property and get Medicaid. Another thing that people mention all the time, even if I take the right things and I go to a lawyer and I do the right things and I transfer the house in time, they're going to come after me anyway. It's called estate collection. If done right, there will be no estate. Therefore, there will be no estate collection. That's why it is so important to go to someone competent who knows how to protect assets. Very important. I'm not a lawyer. Ron's a lawyer. There are a lot of lawyers out there. There are a lot of Medicaid people out there. When people come into me and they ask me and they say, I have someone I know, we have a friend, we have a cousin's grandmother's uncle who does this, blah, blah, I tell them, you can go to anyone you want. Just make sure that they are competent and understand Medicaid's estate collection laws. Because if you're going to go to save yourself a couple of $1,000s, it's not worth it. They're going to take the house away after 120. It's silly. Make sure you go to somebody competent. Another big whopper out there. My parents or my father, they make too much in income. Social Security is too high. Pension, gets a pension. Board of Ed, too much. Understand something. Income is never a disqualification. It's never, I should change that. It's never a technical disqualification. It may end up being a practical disqualification. By that I mean, if somebody is lucky enough to have monthly income of $10,000 based on their Social Security and their pension, they got $10,000 in monthly income. It's practically silly for them to apply for home care Medicaid because the income is way too high. You might as well just hire privately with that kind of income. But when you're dealing with income of anywhere, you're over by $500, you're over by $1,000. Do you want to maybe just shut it off because it doesn't shut off? Okay. You're over by $2,500 every month. Anybody know the amount of money you're allowed to have income, Medicaid in New York State? It just went up by $20. You're allowed about $840 monthly. $840. I see people laughing, right? $840. And the typical question I get from everybody is, how do they expect me to live? Okay, they don't expect you to live. They don't expect anything. It's called federal poverty levels, and they have a whole algorithm that they use, and it's $845 whether you like it or not. So just deal with it. And we in the office and other people who know this well, deal with it. The biggest thing you can do is a pooled income trust. I'm going to get into that in a minute. But just keep in mind and remember this. Income is never a disqualification. Not a technical one. Another big one people always say, isn't there a 5-year look back on Medicaid? Everybody says that. Ron touched on it. There is only for nursing home. Only for a nursing home. So many people want to try to have their parents or loved ones avoid going to a nursing home if possible. Sometimes it's unavoidable. But if possible, and these days it's very, very possible to have someone cared for at home, even on a vent, even with a trach, even with the most extensive medical equipment. There are so many things you can do with trying to keep a parent home. within reason. Sometimes it's dangerous. But a lot of times, it's very, very smart to do it. Number one, because they want to be, the home environment is the best usually. And number two, for financial reasons. There is no look back period in New York State. Nassau County has like about 3 months. You have to have 3 clean months. So that's like the biggest look back there is. Nassau, Westchester, Suffolk, 3 months. New York City, 0. Technically speaking, today is, I don't know, December 28th?
Yeah.
You can technically, all day, yeah. You can technically transfer assets tomorrow and qualify on New Year's in New York City. Nassau, you're looking about March or April time. There are so many things you could do. Community Medicaid, no look back. Nursing home, look back. Understand that distinction. That is like one of the biggest misconceptions out there. Very, very important. Another thing that's very important is, I go through this all the time. I met someone downstairs and I meet people every day like this. My father is protected because he went to a lawyer and they created a trust. Please be aware, creating a trust is meaningless unless you fund it. How many people come to me and say, my parents went to a lawyer 7 years ago, they spent thousands of dollars and they set up all the papers. All I do is go to Acris, which is the public website out there, to look at a deed, and I check the house. It's still in their name. Because the father was hesitant to take the next step. They opened up the box, they created the box, they created the safe deposit box, but they didn't put anything in there. So what good is it? People don't realize that. And the father, a lot of times, the parents, that's a way for them to push the kids away. We did it already. Tatala, we did it. It's all done. They don't realize it's meaningless. It doesn't start anything. You have to take the step of, obviously, in a respectful way, convincing them that this has to be done. It's so important. Number one, for community Medicaid, you qualify, as we said, pretty much right away. So if they need an attendant, a lot of people are probably paying privately for private pay home care. It could cost thousands of dollars out of pocket. Thousands. We're talking pretty much, even if you find somebody privately and you're paying them cash, you're still dealing with a good $2,500 to $3,000 of out-of-pocket expenses. That's money that could be absolutely saved. I once had a consultation, brother and the sister. He was the lawyer, she was the doctor. They came to me. They said, for the last year and a half, they've been laying out of pocket for the mother's home care. Why? Because the daughter, who's the lawyer, went to the local Nassau County Department of Social Services. And they asked her, what does your mother make Social Security? She said, $1,200 a month. Too much. You're out. Didn't understand that Medicaid people at the local offices don't understand this. They know how to disqualify you. They're not interested in having you join the rolls. They're not interested. But legally speaking, she was over by about $400. Even if you forget all these fancy schmancy pooled income trusts that I'll talk about in a sec, you could actually pay the $400 a month. So the brother and sister told me over the last year and a half they spend $115,000 out of their own pocket to have their mother cared for 24/7. That's not a shock. That's what these things cost. And I guess they did okay for themselves, so they had the money and they were able to support the mother. It's beautiful, but silly. Until somebody in my office convinced me to go see you. I said, we could have her on Medicaid in a week. In a week, we could have the home care referral set up. So these are the kinds of things that you just have to realize. I always tell people, if you're not sure, there's so many variables. If you're not sure, go see somebody who understands these issues. Go speak to somebody who understands these issues. There are a lot of people out there who will even give you a free consultation. So do it. If you trust the person, do it. Whatever it takes, just get the information. Don't be misinformed. I want to go over a little bit about pooled income trusts. Very important. Eli Hecht was supposed to be here. He couldn't make it today. I want to just be marshal him, I guess, what he would have said. Pooled income trusts. Very, very simple to understand. Suppose somebody is making Social Security income $1,845. They're exactly $1,000 every month over the limit. Instead of saying, my father doesn't qualify, you get the home care. You get the Medicaid, fully approved. Every month, after the 1845 pops into his local Chase checking account, all you have to do is make sure that $1,000 every month gets transferred from the Chase checking to a certified pooled trust foundation. There are various foundations out there. Some are good, Some are not so good. Do your research, but the pool trust is a tremendous tool to be able to save income and get on Medicaid. You transfer the $1,000 to the pool trust. The foundation then will pay any and all living expenses for the Medicaid recipient. I always recommend to make sure that you try your best. When you set it up initially, when people work with our office, we try to help them. That's part of what we do, to help them on the initial setup, to make sure that every month you're almost completely exhausting the $1,000. So think of it like some certified gemach. You put the $1,000 in there, and every month you kind of want to make sure that at the end of the month the whole $1,000 is used up on expenses. So there are some easy ones. There are some easy expenses. There's rent. That's a big one. There's groceries. That's a big one. There are gas and electric and utilities and cable and all kinds of phone bills that could be paid by the pool trust. I always recommend to people, if you're in the process of doing this, think of getting your parent a credit card. Even if you say, oh, the bank won't give them. They'll give them a small credit card with a small limit. Get a $2,000 limit. It's not a lot. And this way you go shopping for them, swipe the card. Not a debit, credit. We want to make sure we generate a bill. The key is to generate a bill. You want to use up the $1,000. So if you don't use up the $1,000, the money's not lost. It rolls from month to month. Month to month it rolls. The money is never lost unless you generate a balance over the months, and then after 120, whatever is left over as a balance is lost. You cannot even use it for expenses for the LaGuardia. It's completely lost. So that's why it's important. Either you do it on your own, or you speak to someone who's done this hundreds and hundreds of times to set you up initially with a plan of what we're going to use it for. And this way the expenses are pretty much exhausted. If you leave over a little bit, not so bad. You know, it'll come Pesach time, there'll be a bigger grocery order, you'll be able to spend it, you'll be able to use it up. These are the kind of things. If you have a large excess income, one of the things that I recommend, it's one of the big ones I recommend, even though it's a little uncomfortable, you set up what's called, for your loved one, you set up a prepaid funeral agreement with the funeral home. So it's going to run $10,000. Put it on a 4-year plan. It's going to have you divide it by 48 months. It'll come up to whatever it comes up to, a few $100s a month. Have the pool trust pay it every month. So if your parent has a $3,000 excess income, you got to come up with ways, because generally speaking, the rent and the groceries won't add up to $3,000.
Good.
A big one to understand. A lot of people may have done something called, either you transferred the house to the children with what's called a life estate, or you may have gone to someone competent like Ron, and he would have set you up with a trust with your parent or parents having the right to live there for the rest of their lives. That gives them the achrayas of paying all the bills. So you don't need to worry and say, oh, but the house is not theirs, it's really in the kid's name. Chances are, if it was done right, it was done with this life estate provision, which gives them the right to live there. That right to live there, rent-free, gives them the achrayas of paying all the bills, including the property tax, including everything on the house. So this is another way to use up the excess income from the pool trusts. Another big one I wanted to explain before we get to the questions and answers. Assisted living. It's a big one. Most assisted livings, in New York, are privately owned, private pay. The room and board is private. However, most assisted livings will allow Medicaid home care agencies to come in to provide the care. In most cases, most of the assisted livings make a bulk of their money on the care packages. The room and board could be $3,500 a month, $4,000 a month. You go to a fancy Atria or Sunrise, $5,000 a month, whatever it is. But the care could be just as much, and you're paying double for the room and board and the care. But if you apply for community Medicaid, the care part is all covered by Medicaid. It's a big savings. People think assisted living is nursing home. It's not. Assisted living and home care in the assisted living covered under the community umbrella, not nursing home. There are a few facilities, not many, but a few for those people living around here, maybe in Queens. You've heard of places like the Boulevard. The Boulevard is part of Medicaid's assisted living program, meaning Medicaid will actually pay the room and board. but there's very, very few facilities. There's one downstairs, I believe, is on the ALP program, the Assisted Living Program. The Long Island Living Center, I believe, is on the ALP program. I'm not 100% sure. You can go down and check. If they are, that means you can qualify for community Medicaid, have the person go into the assisted living, and the room and board is covered by Medicaid. You have to contribute the income, though. Income is always what you have to contribute. So if your parent is making, your mother's making only $679 Social Security, and that's her whole income, it's a perfect opportunity. Sign her up for community Medicaid, and if she's willing, have her stay in a beautiful assisted living like the Boulevard, Long Island Living Center. These are beautiful places, and they really, it's a tremendous quality of life for your parents.
Thanks.
Okay?
Thanks, Peter. A few questions that we have. For spouses, do you need power of attorney and a healthcare proxy? Absolutely. Being married is not an automatic right to make medical or financial decisions on behalf of your spouse. In fact, we see oftentimes where one spouse would make actually decisions to the detriment of the spouse. So it has to be appointed in writing. Who administers the trust? There would be a trustee. That could be a child or a relative, and they're the ones who are responsible to handle the trust. Penny, let's try this one. How long will Medicaid cover home care or nursing home care? Does that say Medicaid or Medicare?
It says Medicaid, but that's a very important point. I wanted to get into it, but I don't think there's enough time.
Right.
Very important part. To understand your parents' short-term insurance, Medicare care is short-term insurance. Short-term, meaning doctors and hospitals. Medicaid is New York State's long-term care program. So if your parents either didn't or didn't have the finances for it and couldn't afford it, most people do not have any long-term care insurance. So the home care is considered long-term care. Nursing home, of course, is considered long-term care. Medicare will not cover that. Now, Medicare will cover in a nursing home, depending on what Medicare you have. You either have what's called, on the handout, it explains it a little bit. Medicare, you either have regular Medicare, or you have Medicare Advantage. Now, let me tell you, they call it the Advantage. In the industry, we all know it's really the Medicare Disadvantage plan. But they call it the Medicare Advantage plan. It's an HMO. So you either have straight Medicare or the Medicare Advantage plan. Those Medicare will only cover 20 days in full. The next 80 days, there'll be a copay if you have regular Medicare. A copay. The copay is enormously expensive. It just went up now in January to $157 a day. Times 80, that's $13,920. So if you just have only straight Medicare, please make sure your parents buy a Medigap policy. Medigap, they pay for a gap policy. If they have the Advantage plan, they may cover it, but remember the HMOs are very likely to cut off your service way early, saying that your parents don't need it. The Medicare will only cover what's called progressive rehab, only if they're progressing. If they do what's called plateau, Medicare can stop after day 26. You don't get the 100 days. It's a whole speech in itself, I'm sorry.
Penny, can you put IRA distributions into a pooled trust?
You cannot. IRA distributions, you cannot. You can put, well, they go into your regular account. So of course you can put you can't put it monthly if you set it up monthly. The IRA distributions are generally taken annually. They go into your regular account. However, they add to your income. So for example, somebody's getting a $1,200 check at the end of the year from an IRA distribution. Divided by 12, that's $100. Add that $100 to their regular reportable income on Social Security. So if the person's getting $1,200 Social Security, they're now getting, according to Medicaid, $1,300 a month. The excess of the $500 or so, that goes into the pool trust. But the actual distribution itself does not go straight into the pool trust. It goes straight into your local checking account.
What is the difference between a Medicaid irrevocable trust and an irrevocable trust? There are many different types of irrevocable trusts. Oftentimes they're done for estate tax planning. So the difference between an irrevocable trust and a Medicaid irrevocable trust is that the Medicaid trust will have that language that is necessary, that tracks the legal terminology and the statutes and regulations to make it qualify for an individual to qualify for the Medicaid benefits. Please explain the process and how it works. Asset protection trust, house and money. A person who owns a house that sets up an asset protection trust would have to have a deed transfer and all the necessary paperwork along with that completed so that the title to the property goes into the trust. Money, it could be as simple as changing the name of a bank account or a brokerage account. Again, you can't do these things on your own lest you run the risk of doing something wrong, triggering a tax. We've had people come in and say, oh, I read that you have to have your assets below $14,500, so we close out the IRA. Well, IRAs are exempt. And then the person had to pay a big income tax because all of that deferred income in their IRA came to roost. So it's not so simple. If a person has life insurance, will that affect the estate or what's owed to pay back? Generally not, because Medicaid only has a right to go after probate assets. So a life insurance policy should have a designated beneficiary, like an IRA or a 401k. So that will pass automatically by operation of law, and the life insurance will not be subject to an estate recovery. Penny, answer that one.
Keep in mind just the life insurance. For Medicaid purposes, only policies that are whole life with a cash value are the only ones that affect Medicaid eligibility. If people have term policies only, they're totally exempt from Medicaid, and Medicaid does not even look at them.
This last question, will Medicaid go after property owned in Israel? Speak to Penny after the session. Okay, folks, we held you over a couple of minutes. It's 6:48. Penny and I will be remaining here, but the next session begins in about 12 or 13 minutes. So thank you all for attending.